Well, good morning, everyone, and thank you so much for joining us today. My name is Valerie Ploumpis, and I'm Equality California's National Policy Director. Today's our 10th and final webinar in the COVID series that have been supported by the AT&T Foundation and Sempra Energy. This is funding that we've received in order to help our community, the LGBTQ community, respond to the economic crisis that was caused by the COVID-19 pandemic. Today we have our topic, it's guarding against eviction during the COVID crisis. And we're delighted to welcome back Joshua Christian. He is the Senior Counsel of the Legal Aid Foundation of Los Angeles. You may recall that he spoke to us back in July about what happens when someone can't afford their rent, what rights they have under state and municipal law, and really what to expect during the eviction process. So, it's interesting because we got more questions about his webinar than any other topic that we've had, I believe. And it's obvious that this is an ongoing area of discussion, given that millions of people have lost their jobs because of the pandemic. They've been furloughed, they've lost income from side gigs, any other income generating opportunities, and now they're no longer able to pay their rent. So we asked Joshua to come back to talk to us a little bit about what's happened since July, so he can update all of us on what's been happening in the city of Los Angeles in particular, but also some of the broader areas statewide. So I'll just tell a little bit about our website. Equality California has a website, COVID-19 at eqca.org. There you'll find a ton of links to services that are being provided at the federal level, at the state level, municipal level, and all sorts of topics. We also have a telephone helpline. People can use it. They call and they can ask questions about their own personal circumstances. Many of us on staff are volunteering to be on the COVID helpline. So if you have a personal question, just let us know what county you're calling from, what you need, and we'll put you together with different resources, whether it's COVID testing in your local area, if you have problems with domestic violence, food assistance, rent problems, etc. So as always, our webinars are being recorded. They'll remain accessible on our website. Today, if you have any questions for our speaker, Joshua, please put them in the chat box. We'll be able to answer them throughout the presentation, and at the very end, we'll have a lengthy period for questions and answers. So, Joshua, I'd like to welcome you. Thank you so much for coming back to speak to us today. We're really grateful to you.
Thank you. It's my pleasure. It's good to see you. I'm going to jump in at the very beginning and say that thank you for gunning for me for a promotion, but I am a staff attorney at the Legal Aid Foundation Eviction Defense Center. So, senior counsel, maybe at some point, but right now I'm a staff attorney. In any case, so I'm just so I'm gonna jump right in. I'm gonna start sharing my screen here, and I just did it a moment ago. Now it doesn't want me to. There it is. Great. Okay. So as I said, my name is Joshua Christian. I'm a staff attorney with the Eviction Defense Center at the Legal Aid Foundation of Los Angeles. I work primarily out of our Long Beach office, but I work out of courthouses all around the county. I today am just going to go through a quick presentation. Valerie mentioned I was with Equality California a few months ago, explaining what was going on over the summer with the various COVID-19 eviction protections that were in place. There has been a massive change in the landscape. Clearly, the pandemic, the crisis is ongoing. There was an extremely important state tenant protection law that came out at the beginning of September. There was a federal order that came in from the CDC, and there are a lot of local protections still in place. So I'm going to run through those with you guys today. That's primarily what we are going to focus on. Now, that said, I am just going to start out with this is the Legal Aid Foundation of Los Angeles. I want to make sure you guys understand what kind of services we provide, because it's not just eviction defense that we do. We do all sorts of things, and everyone is in need of all sorts of legal services right now during the crisis. And I want to make sure that folks in LA know how to contact us. I'm then just going to quickly go through the actual eviction process in California. A lot of people, and unfortunately a lot of people that are in this situation now for the first time, they aren't familiar. If you're facing eviction, people might just be guarding against it ahead of time. But I want to make sure that people know exactly how the process works, because that's going to be important to frame all of these laws and understand them. Then I'm going to get into the meat of our presentation, which is the various protections. It's federal, state, and local. I'm going to dwell most on the state level protections in the statewide in the state of California, because as I'll mention, our state law is in general more useful than the federal CDC order. And the local protections are just very specific to LA County. And so I'll just urge all of you to look into your local protections, and I'll stick with state law primarily. So Legal Aid Foundation, who we are. The Legal Aid Foundation of Los Angeles has been around since 1929, serving communities in need around Los Angeles. We have various different programs. We have 5 offices around the county. We run self-help centers out of various courthouses and domestic violence clinics. We are running on a daily basis from 9 to 12 a legal assistance line that gives legal advice on all of our different issue areas. And we're proud that we reach as many people in the community as possible. There were more than 100,000 people that we were serving in 2018, and I think it's gone up since then, but don't quote me, but I assume. So if you need to contact us, and in particular, if during the pandemic you need to contact us because our offices are largely closed, go to our website or call our hotline down there at the bottom. This information is going to come back at the end of the presentation, and Valerie's going to post the presentation as well on the website. So give us a call. Even if you don't qualify for our services due to income or assets, we can refer you to other organizations to get some help. We specifically provide civil legal services in a lot of different areas. I'll leave you to look at these areas on your own, but you can see we do a lot of housing and eviction defense work, immigration, government benefits, student loans, basically across the spectrum of civil legal issues. We also have various programs that are targeted towards individual communities. So people experiencing homelessness, the Asian and Pacific Islander community, Veterans Justice Center, just quite a few work groups. Also, really importantly, in the context of this presentation is that we are heavily involved with the Right to Counsel Coalition, which is a group of legal services organizations in Los Angeles that is working to provide universal access to eviction defense attorneys for all tenants who can't afford their own lawyers, which is a huge program that we're standing up in LA County right now. So the website for that is at stayhousedla.org. So if you do receive an eviction notice in the County of Los Angeles, you can call LAPLA, you can go to our website, you can also go to Stay Housed LA to get put in touch with an attorney if you qualify. Okay, so that's us. A little bit longer than I expected probably, but now I'm just going to get into the basics of the eviction process in California. So I'll keep this short. We don't need to go into the civil procedure class. I am not a bar exam instructor. Don't go take the bar exam based on this presentation. But basically, there are 3 stages to the California eviction process. So we begin with the notice stage. And after the notice stage, we go to the actual court case stage. And then after the court case, if there's an adverse judgment, there's the final stage, which is the lockout. We're going to be focusing primarily on the notice stage. And the notice stage is important because, of course, we want to make sure that everybody's empowered to prevent an eviction notice ever showing up. And the state law can help you do that. We just need to make sure that everybody understands how this works. There are a lot of different kinds of eviction notices. There are at-fault notices, no-fault notices, just cause, no-fault notices. I won't go into it, but the most common kind of notice is an at-fault notice that you didn't pay your rent, right? It's a 3-day notice to pay rent or quit. We're all just kind of familiar with that from the television or something to that effect. Just from living in California, you know people that have received these before. Really important thing to understand about a notice. First of all, notice requirements under state law have changed when a case is based on non-payment due to coronavirus. But where I find a really dangerous misconception with tenants sometimes is that whether through simple misunderstanding or through bad faith, a landlord might give a tenant a 3-day notice and say, pay the rent or I'm calling the sheriff. And that's really dangerous because what's essential to understand is that in the state of California, a tenant has due process rights before they can actually be ejected from their unit. If you have a colorable claim, a good claim to a tenancy, your landlord gives you the notice as a prerequisite to going to court, but your landlord has to take you to court. So when your landlord gives you that 3-day notice, it's a note from your landlord, right? Your landlord can't call the sheriff. The sheriff will say, bring me a court order, and then I can go take that tenant out of their unit, right? And so the landlord, when they go to court, have to attach the notice to the court filing, but by itself, it's not a legally effective document, okay? Another important thing is if you get a notice, definitely consult with an attorney, because the way that a landlord gives you a notice is very technical, and the landlord has to strictly comply with all the laws related to giving you a notice if they're going to go try to evict you on the back end. So it's really important to consult with a lawyer to make sure that your landlord checked all the boxes when they tried to do that. So after the notice has been served, then the landlord can take you into court. And they have to go all the way through the court process and get an adverse judgment from a judge or a jury and a court order before they can actually remove you from your home. So the actual court case, I won't dwell on too much because that's technical. That's my job. That's about litigation. The most important thing for you to know is that after the notice that your landlord gives you expires, you know, your landlord gives you a notice today on the 12th, you aren't able to make your rent payment by the 19th. And then, I'm sorry, by the be different under the state law, but let's say regular law by the 17th. And then your landlord can serve you with a summons, like in an ordinary lawsuit. But the timeline in an eviction suit is very fast. So the most important thing in an eviction suit is that if you are served with a summons, get in touch. Don't panic, right? But file an answer. Get in touch with an attorney. Go to one of your local self-help centers, and there are self-help centers all over the state of California, and get your answer filed, because you only have 5 court days, which is kind of like 5 business days, to file an answer, or you can lose the case automatically. That's a lot faster than usual lawsuits work, and that's because evictions move very, very quickly. I will say a lot of local jurisdictions have been giving tenants extra time to answer during the pandemic, but consult with an attorney to make sure that your local jurisdiction does that before you assume, because of course we don't want you to neglect to file that answer. And then after that answer is filed, you get into litigation. There are all sorts of litigation mechanics. The most important thing to know is that usually by the time, if your landlord moves as fast as possible, requests a trial as fast as possible, then at least in LA County, it can move a little bit faster elsewhere. But at least in LA County, from the service of the summons to the very final judgment is usually going to be at least like 4 weeks. And almost always it'll be longer than that, but I'm saying worst case scenario, the landlord who's moving like a roadrunner, you know, that's how long it's going to take. And so that's important to know. If you are facing a situation where you have legal protections, you don't, you know, that's an important reason not to panic, not to flee your home when your landlord threatens to call the sheriff. Then the very last stage is, of course, the actual lockout. And that's when the court issues an order, the landlord can take it to the sheriff, and then the sheriff will post a notice to vacate. And don't mix that up with a notice from your landlord. A notice from the sheriff is posted on your door and will say notice from the sheriff, 5 days to vacate. And that actually means that you've got to go or they're going to come and remove you. There are some kind of emergency motions that you can make to get a little bit of extra time in cases of extreme hardship. We have had a little bit of success due to the pandemic with saying, hey, this person needs some extra time in some exceptional cases. But, you know, I don't rely on that as a form of relief, and of course, talk to an attorney right away. Okay, so that's the basic eviction procedure. And you know what? I'm going to throw out 2 caveats right away. Number one, the legal term for an eviction in the state of California is an unlawful detainer, meaning that you are detaining a property unlawfully. That's just a technical term. I try to stay away from it as much as I can during these presentations, but I'm definitely going to lapse into the jargon. So just know throughout this, an eviction and an unlawful detainer, same thing, one and the same. Also, I'm advising everyone about the worst case scenario when they really, really have to work hard to protect their rights against a landlord who's not respecting those rights and not respecting the law. I don't want to suggest that every landlord is somehow not respecting the law or victimizing their tenants or something to that effect. You might hear me kind of think about things that way, but it's just because I'm an eviction defense attorney. So hopefully that makes sense. There are many, many landlords out there who have wonderful relationships with their tenants and are working together with them during the crisis. And I don't want to, impugn property owners in general. Okay, so that's that. COVID-19 eviction protections. There are 3 levels of protection in the state of California against eviction. There is a federal order that is in effect in California, and I will go over it very, very briefly. That order came into effect at the beginning of September 4th. There is a state law that came into effect on September 1st. Assembly Bill 3088, we also call it the Tenant Relief Act of 2020. It is a relatively powerful tenant protection law. It's not perfect, it's a little bit complicated, but in terms of state versus federal and local protection, you're going to hear me say again and again and again, make sure to comply with the state law, right? We do hope that there are tweaks and changes and stronger protections that are put in place, but that state law applies everywhere in California, and there are some powerful protections there as long as you know how to take advantage of those rights. Then there are local protections. Like I said, I practice in Los Angeles. I can't necessarily speak to protections that are in place in Oakland, in Berkeley, in Sacramento, whatever it happens to be. So I end up just kind of going over the LA County protections for the sake of any LA County tenants that are watching, but also just to give tenants in other jurisdictions kind of an idea of what other factors their local jurisdiction may or may not be protecting them from, and encourage you to go out, consult an attorney, consult your local housing department that might have information about this, and just make sure that you understand your local protection. All right, let's kick it off. So the CDC order. The federal CDC order came into effect toward the beginning of September. It is largely considered a last resort for tenants in California because the state protections, as I said, are generally broader and stronger. County protections, at least in Los Angeles, are often stronger as well. So I'm just going to run through it quickly. That it applies in all cases. The wording of the CDC order technically applies in every single eviction case. And it just basically says landlords can't evict tenants until January 21st. So its essential function is to say, no evictions, we are just delaying evictions until January 1st, 2021. And one good thing is that there are serious penalties for violating it, but there are a lot of caveats in this order. So it says all evictions delayed until January 1st. Well, first of all, the state law will actually prevent eviction in a lot of cases rather than simply delay them, or it will delay them for a much longer time in the case of local laws. But more importantly, the CDC order requires you to make a very specific certification of your inability to pay rent on the basis of the coronavirus. And you have to make this certification under penalty of perjury. It also, after saying all evictions are covered, then exempts these categories: criminal activity, health and safety, damaging the property, building code, any other contractual obligation, meaning any other breach of your lease. So even though it appears very broad at first blush, there are some narrow limitations on it, which is why we really only consider it as last resort. And we encourage you to speak to an attorney. If you're in LA, call LAFLA, go to Stay Housed, and figure out before you decide that CDC is best, whether that's going to be your best option. Okay. Just reiterating, enacted September 4th, and the issue is, I'll draw attention again to the severe criminal penalties that are in place. So that is one thing good about the CDC, is that the penalties for a landlord violating are massive. So it is a real disincentive to landlords if you are covered by the CDC order. Okay, here's the big one. the California COVID-19 Tenant Relief Act, AB 3088. So this law came into effect on September 1st, all across the state of California. It is complex, but it does provide broad protections, particularly for tenants who are facing non-payment cases between March 1st and January 2021. So it's a long span of time. The protections are relatively powerful, but you need to know how to comply with it in order to make sure that you have those protections. So one thing is that across California, a landlord can now not evict any tenant without just cause. And this is a little complicated. What just cause means is simply, it refers to another state law, but in general, what it means is that your landlord can't evict you for no reason, right? There are a lot of properties, there are many properties that are protected by state just cause protections already, but there are also properties where a landlord can still give a tenant a 60-day notice and just go post a 60-day notice on the door and say, you know what, I don't like your face, get out of here, I want to move somebody else in, right? That until January 31st, 2021 is no longer legal in California. A landlord has to be able to give a just cause like, I am withdrawing the property from the rental market. I am moving in a family member. You didn't pay your rent, right? Those just causes need to be a basis for eviction through the end of January. So important other things here. So like I said, most of the protections and the most detailed protections in this law have to do with non-payment cases. So number one thing, in order to be a covered tenant under AB 3088, you have to send a very specific declaration to your landlord. The declaration is pretty much laid out line by line in the civil code. That said, that is, as I said, it's specific, but it's very, very simple. What I recommend is that you go to LAFLA's website and we just have a sample declaration. Here is it, it'll satisfy the law, sign it and send it to your landlord. We recommend that you sign that declaration within 7 days of your rent coming due every month. It's not required by the law necessarily, but we do just as a matter of standard practice, we say, look, if you can't pay your rent, rather than paying your rent, send the declaration instead. Rather than a rent check, a COVID declaration, right? Another really important protection is that, and this is why the law does not necessarily require that 7-day noticing within the day of the rent coming due, whereas before enaction of the Tenant Relief Act, a landlord was required to give you 3 business days notice in order to pay your rent, and then could move to evict you. A landlord that is now seeking to recover any unpaid rent between March and January 2021 has to give you a 15-day notice. They have to say, you have 15 days to pay this rent. And with that notice, they have to attach one of those special declarations and say, hey, you got 15 days to pay your rent, or send me that declaration and then you'll be covered by AB 3088. And we'll talk about what it means to be a covered tenant. But it just means that you have a lot longer to get your ducks in a row. And if your landlord does not give you that 15-day notice, then you will end up with, then you're going to end up with the case getting thrown out in court. It's required. It doesn't matter if your landlord thinks you're COVID impacted, doesn't think you're COVID impacted. If the rent came due between March and January, they have to give you a 15-day notice and an opportunity to tell them so. There are also increased penalties for retaliation and harassment for tenants that are COVID impacted and taking advantage of their rights under this law. Now let's get into the complex stuff. So what you can do under AB 3088, that's pretty nifty, is that you can take a large chunk of your debt that comes due between March 2020 and January 2021, and you can convert it permanently to consumer debt. And what that means is that that debt is still owed. It's not that you don't ever have to pay that money. It's not cancellation of rental debt or anything like that. It's owed like a bill. It's owed like a medical bill, for instance. Your landlord could go after you with a bill collector. Your landlord could sue you in small claims court. But now that it is consumer debt and not rental debt, that debt is no longer the basis for eviction. So although it may be a problem as we are all struggling, as the economy is slowly getting back on its feet, as we're all trying to deal with the economic impacts of this pandemic, and it's another thing that we're hoping the legislature can work to deal with in the coming year is, the possibility of consumer debt. If people can satisfy AB 3088, their housing will not be under threat for non-payment of COVID rental debt. So, number one thing to satisfy AB 3088, you're going to hear me repeat myself a lot, is to send that declaration, right? So once you've sent the declaration, you are now a covered person. And that means that your March to January debt is COVID rental debt. These are all just the terms from the law. It's not that important. The important thing to know is that as soon as you send that declaration, March to August becomes consumer debt. Boom. Your March to August debt can no longer be the basis of eviction. You owe it, you got to pay it. There are a lot of weird legal mechanics about when exactly you have to pay it, when your landlord can sue you, et cetera, but you can't be evicted for it. Now, September to January is where it gets complicated, okay? So from September through January, by the end of January, you're going to have to pay a quarter of all the rent that was due for that time. Now, that rent does not need to be paid on a month-by-month basis, and we're finding that both tenants and landlords are getting very confused about this. So let's say you pay $1,000 a month in rent, right? And September you can't pay, October you can't pay it, so you've lost your job. So between September and January, you can't pay that $1,000 a month in rent, right? What that means is, stay with me on a little bit of math, by the end of January, you have to pay your landlord $1,250 total, right? That's a quarter of your rent for each one of those months, $250 for September, $250 for October, $250 for November, December, January. But you don't need to pay it on a month-by-month basis. You just need to have that full amount paid by January 31st. So we do find landlords coming to tenants and saying, you owe me $250, you owe me a quarter of your rent. They know what the law is, and they often are trying to follow it, but there is that confusion. And of course, if you've lost your job and you're not working between September and January, the whole intent is that you have from September to January to try to get at least a quarter of your rent together. Now that is essential because not until you have made that payment does the rest of the rent become consumer debt from September to January. And so it's very, very, very important to make that payment by the end of January. But as soon as you do, just like with March to August, you still owe the rest of that rent. Your landlord can sue you. It's a bill, but, yada, yada, yada. But it can't be the basis for eviction. And that's a place where that's the reason that we say, the state law is in general stronger than the CDC order, right? Because the state law does not delay your eviction. It does not say, hey, look, if you're COVID impacted, your landlord just can't come after you to evict you until January 1st. The state law says first of all, you have until January 31st. And if you satisfy these requirements, you've got to pay this money, but you can never be evicted for failing to pay this money, this particular rental debt. I'm going to review. Told you I'm going to repeat myself a lot. So now that the state law, the COVID-19 Tenant Relief Act, AB 3088, all the same thing, now that this has been passed, all notices to pay or quit for COVID rental debt, which is March through January, a landlord has to give you a 15-day notice, not a 3-day notice. They have to give you that self-certification form with the 15-day notice. Now, we still advise send that form proactively, go to LAPLA's website, pull off our template form, sign it up, send it off, certified mail, keep good records that it was sent. But you have until the expiration of that 15-day notice to send that notice to your landlord. And in fact, as a caveat, if you don't send it, you can go into court later and try to explain to the court why you didn't send it, but the court is going to have to determine that you have a good excuse. So just send it before the expiration of the 15 days. So as soon as you certify that COVID impact, March to August, consumer debt, boom. From September through January, the rent can no longer be the basis of eviction as long as you pay that 25% for September through January by the end of January. Then there is, a little bit of a question about when and how can your landlord come after you for the balance of that rent. A lot of local protections have deferred when a landlord can come after you. It's very complicated. And so we just advise wherever you are, go consult with a lawyer, try to find your nearest legal services organization and just, find out when that lawsuit could be filed. But we do know that your landlord could not come after you, even if there are no local protections in place. They can't come after you until at least March 1st, 2021. Bottom line, AB 3088 is better than the CDC order. It allows you to convert rental debt to consumer debt, which is a big deal. And this is essential, regardless of if you have local protections in place. If you want to be protected by the state law, the COVID Tenant Relief Act, you have to comply with the requirements of that law. So, for instance, in LA County, we had a local order that said you can defer your rent for a year as long as you give your landlord a written notice within 7 days of your rent coming due. Thing is, the LA County law doesn't require a special form of notice. So the concern is that if you get a 15-day notice, you can't comply with the LA County order. You can't say, okay, well, I sent you a written notice and LA County said that's enough. That's not how it works. If you want to be covered by the state law, you need to comply with the state law. You need to send that specific form and pay that 25%. Okay, so that is the state law. We're rounding third, I promise. So last thing is just to go over LA County local protection. As I said, these apply. I practice in Los Angeles, so this is what I'm most familiar with. I encourage you to contact your local housing department, to contact, legal services, find an attorney, because I want to make sure that you are, adhering to whatever your local protections are. Don't go complying with the LA County order. It's not going to help you in Alameda County. But I'm going to go through it both for the sake of any Los Angeles residents that are watching, but also a lot of these local ordinances were kind of formatted or crafted along the same lines. And so this will give you a little bit of kind of an outline of what your local ordinance might look like. So in LA County, as I mentioned, in order to be covered by the LA County ordinance, you have to give written notice to your landlord that you're impacted by the coronavirus within 7 days of when rent is due. Notice that's a little bit different than the state law and a little bit more strict. So if you don't comply with that and you still comply with the state law, you're still covered by the state law, but you might lose the protection of the local ordinance. So that's why you kind of want to know how these things interact with each other. Under LA County, there was a provision that deferred rent payment for a year, but it didn't forgive it. And so there's a really complicated question of what happens on January 31st for tenants that were not able to make their 25% payment. And, the lawyers have debated about this. We know what happens on January 31st, but it'll take me 10, 15 minutes to explain it. So don't, the point is that your local law might defer rent. Maybe it forgives a little bit of rent, but in the case of the state law, that is the one that can actually convert to consumer debt. There's a question about whether commercial tenants are protected. In LA, commercial and residential tenants are protected. That is greater, it's higher than the state law. So there are protections that are there that are better than the state law's protection. The number one thing in LA County that is a huge protection for us is that there are no fault evictions in LA County right now through the end of January. And so remember, I said your landlord can only evict you for a few reasons. If they want to move in a family member, they want to withdraw the property from the rental market. In LA County, even those are not valid until the end of January. The Board of Supervisors has decided, no, we're not we're not going to permit 60-day notices during a public health emergency. And then finally, there are protections against evictions for unauthorized pets, unauthorized nuisance, or unauthorized occupants, allegations of nuisance, if the tenant certifies that they are due to COVID-19. So, your cousin moved in and was staying with you for a little while, all of a sudden, COVID hit, your landlord's coming by and saying, hey, this person isn't on the lease, I'm going to evict you for this. As long as you tell them, hey, this is because of COVID, you get that written notice, then you're protected. Then not just LA County, that's odd, that got a little bit mixed up, but this is very specific to LA County. As a matter of fact, I think just for the sake of time, there are further complex questions in LA County about the way that the county interacts with the various cities. And so the refrain, let's just go to the very bottom here, talk to an attorney. that's the consensus, talk to an attorney. Now, hopefully you'll see this presentation, you'll find it on Quality California's website. You can look over how to comply with AB 3088 and make sure you do that to the best of your ability, but find a lawyer to talk to just really quickly to make sure all your bases are covered. Last review. What have we learned? So we start with the state law, which is, that's supposed to fly in. You start with the state law, which is the California Tenant Relief Act, okay? The state law is cool because it can convert your rent to consumer debt. It has requirements, which are a specific declaration and part payment of that rent. It is best in combination with local laws, which means that local laws could provide greater protections, like in LA County. And there are special penalties for, I don't know that I mentioned that, there are special penalties in the state law for illegal lockouts and for retaliation against tenants impacted by the pandemic. We also learned about county and local laws, which have these greater protections. They can give you no-fault eviction, nuisance pets, and then even give extra penalties for harassment and do some rent deferment, but really they're a supplement to the state law. And then we have the CDC order, which is your last resort. Technically, it applies to all evictions, but then it gives you a bunch of exceptions. You got to send this really detailed declaration to your landlord to satisfy all these conditions. If you fall through one of the cracks, one of the few cracks between the state law and any local laws, maybe the CDC order is your best option, but again, talk to a lawyer. That's my refrain. Okay, bottom lines, do your best to comply with state law. If you're in LA County, you could have protections from no fault or nuisance, and that goes for, any given jurisdiction could have these protections. There are protections elsewhere in California that are as strong as LA County's, but go check with your housing department. And then if you're not protected for some reason by those laws, the CDC order, might at least be able to put off eviction through the end of the year at this point. All right, so if you're in LA County, you can go to LAFLA's website, lafla.org. You can call our number 9 to 12 Monday through Friday. We have housing specialists that will talk to you about any issue, not just COVID-19 and evictions. If you're dealing with harassment, any other thing, and go check out Stay House LA. Wherever you are, go find your local legal services organization. Go talk to your housing department. Find an attorney to talk to about this. So that's our contact information there. I'll just say as just a final matter before we move into question and answer, just that this is a great time for everybody to get involved with these issues. A lot of jurisdictions now are dealing with really serious problems with things like tenant harassment and a lot of animus between landlords who are getting frustrated and tenants who are desperate. This is a time of a lot of change and a lot of advocacy regarding housing rights and the dynamics between tenants and landlords. And so I say, go out and get involved with things and do your best to get involved with these policies and talk to elected representatives and things like that. If you are facing other issues as well, I've said over and over, contact your legal services organizations because we're here to serve the public. We are here to be in touch with the community and to keep an eye on what is happening on the ground. We want to know if there is huge issue, systematic issue with landlord-tenant harassment, for instance, going on in our communities, because to a great extent, it is our job to protect the most vulnerable people in the communities from that. So I think that's all I've got. Go to questions. I'm not going to leave this slide up. I'm going to go back to this one in case anybody needs the contact info. Oh, I guess I'll keep it sharing at least for a bit. What do you think, Valerie?
Yeah, absolutely. I think so. So that was totally awesome. So if you're just joining us now, our topic is guarding against eviction during the COVID crisis. This discussion is being led by Joshua Christian. He's staff attorney of the Legal Aid Foundation of Los Angeles. So we invited him back to speak about the developments in state and federal law in the area of eviction. If you have any questions, as he said, please put them in the chat box and Josh would be really happy to answer them. So as we're waiting for questions to come in, I'm just wondering, so you did a great job of explaining what people should do if they just lost their job because of coronavirus and they anticipate not being able to make next month's rent. But you said under AB 3088 that renters are protected until January the 31st.
Yep.
What do you anticipate is going to happen to renters after February?
Well, we're going to see, right? Luckily, clearly in an ideal world, we're hoping that renters can at least get together by January. They can somehow pull together 25% of their rent. So we're hoping that most people can at least make that payment. And after that, our challenge becomes protecting our clients' credit, right? It's going to be about dealing with the fact that people should not have their credit reports reflecting, or any issue going on with these small claim suits, with landlords going after them with bill collectors, whatever it happens to be. There is also going to be a wave of folks that did not get word, were not informed about this law, did not comply with it properly. There will also be a wave of bad actor landlords that falsely allege that tenants did not comply properly with the tenant protection, the COVID Tenant Relief Act. We have talked a lot about what we refer to as an eviction tsunami in the world of eviction defense advocates. And that is basically whenever our rent deferment plans expire. Over the summer, it was, when is the Judicial Council rule delaying evictions going to expire? Then it became, when are the rent deferment in local jurisdictions going to expire? And now, January seems like a likely date. So we're hoping that there will be some kind of action to strengthen these protections, make sure that we don't run into that tsunami. But that is a concern.
Yeah, of course. I mean, this is happening all across the country. I mean, I remember in New York when, the rental moratorium, protection moratorium was phased out, the impact there and protest across the cities. And, obviously we've got in the state of California, just a tremendous amount of, unaffordable housing and homelessness are huge and burgeoning problems. So this is obviously just going to add to it. So one of the things you talked about was the conversion of rental debt to consumer debt. And I'm wondering, is this a debt that will appear on credit records? Could, say, a prospective employer see this debt and maybe assume that someone they're thinking about hiring might be near bankruptcy and choose not to hire them? What would that look like?
That's what you've described, right? That's it. You've described exactly what it would be. And that is going to be the vanguard battle come next year, and something that we hope the legislature can deal with. Credit issues like that can appear on reports in all sorts of different ways. I will say an eviction can also appear on your credit report, which is a massive social problem that needs to be dealt with in California and elsewhere. Eviction reports on tenants' credit reports just contribute massively to the housing crisis nationwide and in particular in California. But yeah, consumer debt, that is kind of the trade-off that has been made is, well, we won't, because we're converting this into consumer debt, a tenant is trading the landlord's right to kick them out, put an eviction on their credit, but the money can go on their credit.
Yeah.
So.
Yeah. So are these records usually sealed, or are they a matter of public record? And what could people do in anticipation when they do convert their rental debt to consumer debt? Like, what could they do to basically keep the record sealed, or because sometimes, obviously, when you're on the internet, I mean, even though things are officially sealed, if there's some sort of a gap of time when the records are made public again, that they're just available for a $25 fee that employers or potential landlords can access and discriminate.
Yeah, so there is not a lot of recourse for the credit reporting and such, or wage garnishment, things like that. I will say that's an issue with consumer debt. So for eviction cases, that is a huge concern. Of course, we're hoping to prevent as many eviction cases as possible, but I'm glad you asked. The state of California has a provision under our laws that permit parties in an eviction lawsuit specifically to agree to seal the record. That is not the case for all cases. It's not the case that any given litigation can be sealed by stipulation of the parties. The thing is, it has to be stipulated to. So if there is an adverse judgment against a tenant, if a tenant goes to trial and loses and has to move, that's when that record becomes public, because the record is sealed until there is a final judgment against the tenant, and that's when it becomes public and it can go on credit reports. I will say that, as with all litigation, 95% of eviction cases end up settling one way or the other, and sometimes they settle for a tenant to stay, sometimes they settle for a tenant to go. And we advise, it is essential that if you are in this position, if you are advocating for yourself, that you get that stipulation to seal the record put into your settlement agreement. Because if you agree to a stipulated judgment, the law regards that as a judgment against the tenant, even though it's really a settlement agreement. So you need to make sure to seal the record so that it doesn't appear later on.
And so that's not just a matter of course, it's something that a tenant has to request and push for directly, him or herself.
Yep. Yes. And, it is something that is, usually held over tenants' heads by landlords' attorneys. So I can't advise people on individual cases. I usually say, don't get pushed around. Understand that it doesn't cost your landlord anything to make that agreement with you, and it is essential that you have that agreement in the stipulated judgment if you're entering into one of those settlements.
Yeah, that's awesome. So we have a couple comments in the chat box. The first one is just a kudos. It says, no questions from me, but a huge thanks. Took notes throughout. Really appreciate all the information. So we appreciate that comment. And then we have another question. Can we expect any new housing protections from the federal government by the way of the new Biden-Harris administration? Apologies if you've covered this already. And that's an excellent question.
Oh boy, it's an excellent question, but not one that I have an answer to. Valerie, you might be able to answer this better than I would. I don't say I always say I'm a litigator. I'm not a political operative. I actually can't do any kind of, I can weigh in on policy, but I'm not supposed to do any lobbying or anything like that. Regardless, I cannot predict what's going to happen at the federal level. God, who can predict what's going to happen at the federal level right now?
Well, or it wouldn't be anytime soon. Obviously, we have to get through the lame duck period, and then the new cabinet has to come into place. Obviously, Ben Carson has not been any kind of a friend to low-income people who have encountered problems at any level. Homeless shelters and affordable housing and all kinds of things. So we certainly have expectations that the Biden-Harris administration will be kinder, but yeah, you're right. I think any federal relief there might be, sometime incoming. One thing I wanted to ask you about, so you talked a little bit about retaliation and harassment. Can you tell us sort of what some of those forms might be? What sorts of things are illegal for landlords to do? And then maybe it's sort of a related question. It's like, what should people do if a landlord tries to lock them out without taking them to court, not really following the process directly? Like, they come home from work or from the park with their kids and there's a lock that's, the locks are changed on the door. What should people do then?
That is a great Again, you're asking great questions. I have literally a whole other presentation about illegal lockouts that's similarly as long, but I will try to give the highlights. So California, harassment is a huge present issue right now during the pandemic because, as I said, landlords are frustrated, tenants are desperate, people are suffering really shocking things from their landlord right now. I've done this for years. I thought I'd seen it all. I haven't seen it. I had not. And so in a lot of jurisdictions, at least around LA, we're working to get stronger anti-harassment protections in place. And so let me start talking about what the state law says and then talking about what local jurisdictions have done or are trying to do. To begin with, at the top level, the state has a few different protections against harassment, but they generally require a tenant to prove that the landlord was trying to get them to leave, that it was an attempt at what's called constructive eviction, to influence them to vacate the unit. But that's, first of all, you need to prove your landlord's state of mind in order to do that, which is difficult. And also that actually means that your landlord can get away with doing things like banging on your door at 3 a.m. demanding the rent because he just says, well, I just wanted the rent, right? There are other provisions that might help you out, but the state law is very, very difficult to sue under. The new state law has taken those protections and has expanded the damages if the harassment is COVID related. So all the same issues are still there, right? Our state law says illegal lockouts, utility shutoffs, various other, actual threats of violence, those sorts of things are illegal. And then the state law comes, but you're going to need to prove your landlord's intent to evict you, essentially. Or in the case of illegal lockout, you're going to have to actually already have been illegally evicted in order to sue. And then the new Tenant Relief Act has come along and said, and in a case where that tenant is impacted by the pandemic, you've got to pay a few $1,000 extra for each time you do this, which is a big deal, right? Yeah. And what we have been trying to do in local jurisdictions generally is expand the definition of things that are categorized as harassment from the state law and supply more damages to say, no, this is really bad. It's not just the state who's going to tell you that you could take damages. The city of Long Beach, which just passed our anti-harassment ordinance 2 weeks ago, the city of Long Beach is also going to make you pay a couple $1,000s in court if you do this. And so what Long Beach did was we enumerated 13 different things that are also harassment. In most cases, you're not required to prove your landlord's intent. It's simply illegal for a landlord to behave this way toward a tenant. And then there is an extra $2,000 to $5,000 in damages for each time your landlord might do this. So that's great. We're trying to expand on these through various policy initiatives. The problem of access to justice is still very real, which is, and it becomes particularly relevant in the case of illegal lockout. But let's say that someone is being harassed. Let's say that someone, God forbid, is illegally locked out. What's their recourse? It's a letter threatening to sue their attorney. A letter from an attorney threatening to sue their landlord, right? And then follow up to sue their landlord. Well, when? A year later, they're going to get to the end of that lawsuit, maybe 2. Hopefully they can win. Hopefully they can, they're either going to be in small claims or hopefully they can get an attorney to represent them, and landlords who engage in this type of behavior often do it over and over and over and over again. And they get a letter from me saying, hey, my client's going to sue you. And they just crumple it up and they toss it in the trash. And they know that that's not really going to affect their bottom line, which is why putting more damages and a private right of action is really important, because a landlord is used to getting a letter from me saying, hey, this person can sue you for $5,000. Well, great. That's not really that big of a dent. Whereas now a landlord can get a letter from me saying, this guy, if you keep this up, this person can sue you for $50,000. And at that point, they can probably find a private attorney, right? because that's not the kind of litigation we do, unfortunately. Illegal lockouts have a similar issue where on the front end, what is the tenant going to do? A letter from a lawyer and maybe call the police, which is very problematic. It is particularly problematic in communities of color. It's easy for a guy who looks like me to say, call the cops. It's considerably more complicated for most of my clients. The point being, it's the same issue where I advise clients. I usually just say, if you get illegally locked out, you're going to have to call your local law enforcement if you feel safe doing that. Try to stay as calm as possible. And the most important thing is to understand that procedure that I put out at the very front of the presentation. Where is the court order? If the landlord is trying to get the cops to come pull you out of your unit, which happens, if they've illegally locked you out, you need to also have proof that you're a tenant. So I say, keep a copy of your driver's license, keep a copy of your car registration, keep a copy of a recent bill, statement of government benefits with your address on it, carry a written lease if you have it, keep those with you at all times if you think you are in danger of lockout. And the magic words are, this is a civil matter. So you say, I am a tenant, this is a civil matter, can you show me a court order? But even so, that it's up to the discretion of law enforcement at that point, which is, a problematic part of access to justice generally.
Mm-hmm. So what is illegal retaliation and harassing behavior? Obviously, you mentioned 3 o'clock in the morning, phone calls, banging on the door and that kind of thing. I mean, there's obviously, a wide range of things, but what kinds of things, are illegal, like in every jurisdiction?
In every jurisdiction. So let me go through the state law. So Civil Code 1942, one of the main landlord harassment laws essentially deals with things that would likely be illegal under other provisions of the civil or penal code, but supplies extra damages when it's done in the context of constructive eviction. So that is literal threats of physical harm, whether it's verbal, willful, actual harm, threats to report someone's immigration status. I'm not going to be able to pull up every single one off the top of my head, catching me off the spot, but basically actual really menacing conduct, very serious misconduct on the part of a landlord. Surprisingly, it also lists violation of the right of a landlord's right of entry, which is a 24-hour written notice to come in. But it's very easy for a landlord to violate the right of entry. And again, you need to prove intent for constructive eviction, but that is a very common form of harassment that is technically illegal everywhere under state law. Then a different portion of the Civil Code relates to utility shutoffs and illegal lockouts specifically. It makes it illegal for a landlord to shut off utilities, to actually illegally change your locks or prevent you from entering in any manner your unit, or bar entry or exit for that matter if they try to harass you that way, or primarily to remove your personal property without your permission.
And you've seen all of these happen, I suppose.
Oh yeah. Yep. I've seen, disabled individuals with necessary equipment tossed into dumpsters. I mean, I've seen it all. So in any case, what we've done in places like Long Beach is that we've enumerated, there are really important things like, disturbance of the right to quiet enjoyment in unreasonable ways, which is banging on the door at 3 a.m. A very, very important one is knowingly misrepresenting the law to the tenant. So that means that a very, very common thing I see is for a tenant to come in and say, I already moved because my landlord told me that he was going to call the sheriff. And that's why I said this is a really common misconception at the top, right? That notice is not a legal document. In Long Beach, that is now harassment. For a landlord to knowingly give a tenant a notice and say, I'm going to call the cops, is illegal as long as they know that that's illegal. So, and a number of, it's a 13 part. Go ahead.
Thank goodness for high equality states and for the Legal Aid Foundation. you do so much good for so many people. We're really grateful. Joshua, wanted to
Well,
thank you.
I'm lucky to work here.
Yeah, well, we are grateful, just on behalf of the universe for what you do and to protect really vulnerable people. I think we may be posting a little poll at the end to see how valuable you found this webinar. Josh would love to know, how valuable you thought. If you have any recommendations, it would be super helpful for us to know. If you're interested in watching this this webinar again, it'll be on our website as well other things. If Joshua has any further updates for us on eviction laws at the state or municipal level, we would be really grateful. We'd be happy to put them on our website. We'd like to thank you so much for speaking to us today, Joshua. You've been amazingly helpful. Really,
my pleasure. It's always my pleasure. And happy to come back anytime.
Awesome. Thank you very much. We really appreciate it. And to everybody, thank you for watching. We appreciate it. Take care.